Welcome to another episode of the Federal Newswire Lunch Hour Podcast with your host, Andrew Langer.
Well, hey there, everybody. Welcome to another episode of the Lunch Hour with Federal Newswire. I'm your host, Andrew Langer. So glad I can join you and you can join me. And normally I have a whole introduction that I do, but we're going to skip that today because time is of the essence. We're joined today by Congresswoman Harriet Hageman, who represents Wyoming in the U.S. House of Representatives, a rancher's daughter and University of Wyoming law graduate. She spent 34 years as a nationally recognized litigator focused on fighting federal overreach and defending property and water rights. She previously served as an attorney for the New Civil Liberties Alliance and has argued complex cases against federal agencies and before the United States Supreme Court. In Congress, she chairs the Subcommittee on Water, Wildlife, and Fisheries, serves on the Judiciary and Natural Resources Committee, and co-chairs the Congressional Coal Caucus. And today, one of the things we're really going to be talking about is this Republican Study Committee task force focused on reasserting Congress's constitutional authority under Article 1. Congresswoman, thank you so very much for joining us today.
Well, it's wonderful to be with you. I do have one correction. I did not argue before the United States Supreme Court. I did have a longstanding case in front of the United States Supreme Court, an original jurisdiction action. So kind of an unusual type of litigation, but everything else was completely accurate.
There you go. Well, I appreciate that. Thank you very much for the correction. As we go through and we summarize bios, sometimes stuff gets caught in the mix. So let's talk about this because you and I have had a couple of conversations informally about where things are with the regulatory state. I had a conversation many years ago. I was testifying before the House Subcommittee on Regulatory Reform and Oversight and got asked a question about how we'd gotten, and this is 15, 20 years ago, how things had gotten so bad with regulations. and the member, I think, was expecting me to just beat up on the agencies. And I said, well, Congressman, really, this is in no small measure your fault and the members of Congress. Let's talk about Congress's culpability and this effort by the Republican Study Committee and this task force that you're chairing, Congresswoman.
So I would agree with you.
Yeah.
Congress has largely abdicated its responsibility for legislating and turned a lot of that responsibility over to the administrative agencies. And they've done it in a variety of ways. One is like in the Clean Air Act, where it says that the Secretary of the Environmental Protection Agency shall have whatever rulemaking authority is necessary as to carry out the intent of this act. Well, you can drive a Mack truck through that because every secretary is going to try to scrape up as much power and authority as they possibly can to implement their own agenda, not necessarily what Congress intended by the Clean Air Act. And you've seen that with things like the endangerment finding and these efforts to destroy our coal-fired power plants and to force us into electric vehicles and, taking away our gas-fired stoves and things like that.
Oh, yeah.
So Congress is largely responsible for it. But then at the same time, the executive branch has been willing to claw more and more power into its side of the aisle, and thereby making it so that ultimately the people of this country are the ones that suffer. Right now, the economic impact of the federal regulatory overreach is about $2.1 trillion a year. So it's just an astronomical amount of money that is largely a hidden tax that people don't even realize they're paying.
I suspect that's the low end number. I tend to subscribe to what our good friends at the American Action Forum say. Dan Goldbeck over there says that it's approaching $4 trillion. And then that's only in direct regulatory cost. We've done some work using some analysis by economists Dawson and Cedar that for every dollar in direct regulatory cost, there's a $19 multiplier in lost opportunity cost, right? It gets down to what you're talking about with things like the endangerment finding. When you ban gas stoves, like if you're a business, if you're a pizza shop owner and you ban gas or coal-fired ovens, because a lot of them use coal, but gas-powered ovens, and you make them switch over to something else, the money that they spend on putting in new equipment, well, that's money they can't spend elsewhere in making their business more productive. This is part of what we're talking about, isn't it, Congresswoman?
Yes, it is. And it fundamentally changes most of our restaurants, because if you're like me and you like to cook or you own a restaurant, most of your restaurants are going to have gas stoves because you can control the heat much better than you can with electric stoves. There are so many other ways that this has come about. It really started under Hoover,
Yeah.
and then, and then we went to Roosevelt. But it's the last 30 years
Right.
that the regulatory state has been on overdrive. And I think where you really saw it explode was when Bill Clinton lost the House in 1994, he was no longer going to be able to get his agenda through legislatively. So at that point, he started expanding the regulatory agencies just exponentially. And I say that one of the inflection points in this country was one of the very last things he did on his way out of office in January 2021, right before George W. Bush was sworn in as president. He issued what was called the roadless rule. And the roadless rule was issued by the U.S. Forest Service. It denied access, management, and use to 58.5 million acres of land. Largest rulemaking in U.S. history, and still probably the largest rulemaking in U.S. history in terms of real impact. That's why we've had such terrible, catastrophic forest fires in the West. It's why we have the insect outbreaks that we've seen, just the complete destruction of not only an entire industry, the logging and timber industry, but also the destruction of our natural resources, destruction of habitat, the impact on our watersheds. I mean, it's just been absolutely astronomical. And that was done by a regulation, not by Congress.
It's funny because I literally was at a coffee shop this morning and I heard two gentlemen sort of arguing. Literally, this happened. I swear to God, it sounds like a made up story. They were arguing about eminent domain power, under the Fifth Amendment. And I promise you this is somewhere we're going. And I wound up chatting with these guys because obviously that's an issue of interest to me. And we were talking about forest land, and we were talking about the amount of land the federal government owns. We do not know. The federal government has not done a proper inventory of what it owns. And let me add to this, a lot of folks don't understand that national forest lands are managed and controlled by the U.S. Department of Agriculture, not the Department of the Interior. They're not supposed to be managed for recreation purposes. They're supposed to be managed for resource utilization. This plays into that, doesn't it? I mean, you're right. Bill Clinton changed the tenor on all of this.
Dramatically. And yes, the federal government owns about 612 million acres of land in the continental United States and Alaska. So it's just an astronomical amount of property. And they don't do a very good job of managing it.
No.
Between the BLM, the Forest Service, Fish and Wildlife Service, those are your primary agencies. The Department of Interior, those are your primary agencies. And yes, there are 192 million acres make up our national forests. The national forests were created under the 1897 Organic Act, and they were created to provide a continuous supply of timber and a continuous supply of water. They are failing at doing both because the rules and regulations coming out of Washington, D.C. have largely destroyed our ability to access and harvest and use that resource. And it's had a huge impact. The housing costs have skyrocketed in the last 25 years because we import so much lumber from Canada. That's one of the reasons why people are concerned about the tariffs, because that we have to import so much. We have the resources here, but because the environmental groups and the lawsuits that they've filed and the judges who have issued injunctions against the leasing of these lands for timber harvesting, it has really created a disastrous situation, primarily in the interior West, including in Wyoming. We have over 9 million acres of National Forest Service lands. 3.2 million are now designated as roadless.
Wow.
I can go and talk to the people on the ground in Wyoming. They'll tell you that we are destroying this natural resource. We're destroying wildlife habitat because, again, the regulations coming out of Washington, D.C. prohibit them from doing a good job in managing the resource.
I want to come back to towards the end. You can spend a little time showcasing the wonderful merits of visiting Wyoming. But I just have to ask the question with this roadless rule. My father did some graduate work up in Montana in the Beartooth Primitive and has always talked about going back to the Meeteetse Trail between Red Lodge, Montana, and Meeteetse, Wyoming. Is the Meeteetse Trail still open? Do you have any idea?
I don't know about that. Obviously, getting from Red Lodge to northern Wyoming, I'm not completely familiar with that particular trail.
It's an old wagon road. It's a fantasy I have of still taking my dad out there so he could go over these lands. But let's shift back to all of this because you point this out. We have these rules. We have these unintended consequences. Tell us about this effort, the Republican Study Committee task force here that's looking at Congress's power, but how it's sort of dealing with these other aspects of regulation and how this all plays into it.
So I'm the chairman of the Article 1 task force. And what I would like to do is really take that power back that belongs to the legislative branch. And we need to do that in a variety of ways. One, we need to become better at writing laws. And we have some challenges with that, including with our own legislative council. I have had circumstances where I have been advocating that we start using a lot more things such as preambles more, that we state the purpose of this law is X, Y, and Z, then write the bill, write the act, also use more in terms of really specific definitions. And one of the members came to me recently, and he had written a bill, and he included some pretty tight definitions of what was going to be included in that particular act. He took it to legislative council, and they said, no, you need to take these definitions out. Those are for the agency to define. And he's like, no, that's not really what I think we should be doing. I think I should be defining those because this is what I want the bill to say. And they're like, no. You need to give more flexibility to the agencies so that they can write the regulations that they need to. Now, here's what bothers me about that. Number one, it's bad advice.
Right.
And we should be the ones writing the definitions. But in addition to that, they're actually building in ambiguity into the legislation itself so that the agencies can then decide, depending upon who's president and who they're serving at any one time, what those words are going to mean. I vehemently disagree with that. That is not the way that we should be doing it. But here's something else people need to understand. Legislation should be self-effectuating. We don't have to have regulations for every bill that we draft. In fact, if we're good at our job, the majority of our bills should not need regulations to be implemented. If we want the speed limit to be 75, now this is a state issue, of course. But
of course.
If you want the speed limit to be 75, you write the bill to say the speed limit is 75. You don't direct the Department of Transportation to write regulations that the speed limit is going to be somewhere between 60 and 90. That isn't what you do if you want the speed limit to be 75. And that's really what we need to do. We need to be better practitioners. We need to be better at our job. We need to be pushing back against Ledge Council. I'm not attacking anyone in personally.
No.
I'm just saying that we've gotten into the habit to believing that the experts really are the ones that should be driving this, and it isn't. They're not the ones that are accountable to our voters. They're not the ones who are accountable to our constituents. We're the ones that need to write the law, and we need to get rid of the ambiguity and the vagueness that oftentimes is hardwired into these provisions.
Well, it's almost like legislative council doesn't understand what happened at the Supreme Court last year with the Loper-Bright decision, and I obviously we want to talk about Loper-Bright and Chevron deference, not the least of which because I just found out from your former colleague Karen Harned at the New Civil Liberties Alliance. I hadn't realized that NCLA was counsel for Relentless, which was the companion case to that. But does legislative council not understand that the landscape has changed fundamentally in the last year?
Well, I hope so. They should. No. But in addition to not allowing the agencies to interpret what we intend, we don't want courts interpreting what we intend. We want to say what we intend. So the only reason or the only circumstance under which you have to have this interpretation is when we draft a bill that is not specific enough for it to be implemented. We have a due process issue when we write vague and ambiguous bills because everybody is entitled to know what the law is. And it shouldn't be up to a court or a regulatory agency to announce to the world what the law is. We should be doing that as Article 1, as the legislative branch. And so that's what I'm doing is I'm giving courses and I'm teaching my fellow members, giving them a much better understanding, a much more in-depth understanding of what's happened in the administrative space over the last 30 years. And then I'm also bringing in experts, such as from NCLA, to describe the Administrative Procedure Act, what it is, what it was intended to do, how it needs to be amended. I mean, there are a lot of ways in which we need to address this regulatory overreach. One of the areas has to do with administrative law judges and administrative law courts. Agencies like the SEC, they have stood up their own court system. And I don't think it would probably be a surprise to anyone, but they win their cases against us about 95 or 98% of the time in front of their own judges because they're all on the same team. So I've introduced the Seventh Amendment Restoration Act that says if an administrative agency brings an enforcement action against someone, they can remove that to an Article III court. And lo and behold, they only have about a 65% success rate in front of Article III judges. So you're going to see fewer enforcement actions and fewer wrong-headed enforcement actions. You're going to start constraining the agency or the power of that agency, and that's a good thing.
You know, it's funny because I know, and I want to talk about regulatory dark matter. I know you had Wayne Cruz up in front of your task force a couple of weeks ago. Wayne's a good friend, someone whose work I admire tremendously. But the other thing that CEI has done, the Competitive Enterprise Institute, is they have also peeled back on this issue of the administrative courts. And it gets worse when we're talking about interpretation. Actually, let me start with this, which is one of the great things that President Trump did in his first term very early on was he created an executive order saying you couldn't be prosecuted under things that were guidance documents or interpretation letter. At the very least, they had to go through the formal notice and comment process. In fact, one of the ways I think the Administrative Procedure Act ought to be amended is to make it so that these interpretation and guidance documents get folded into this process. But let's talk about the interpretation and guidance documents. Let's talk about this regulatory dark matter and how that affects the landscape.
So let's define what that really means.
Yes.
So under the Administrative Procedure Act, there is a process for formally adopting rules and regulations, and that's pretty time consuming. As you noted, there's a notice and comment period. The regulated community gets to engage with it. There are ways in which the Congress can step in and be involved in that process as well. So it actually was created in 1946 as a mechanism to standardize rulemaking after Roosevelt came out with all these regulatory agencies, because they were just working willy-nilly and nobody knew what the rules were of how to go about creating these regulations. So Congress passed the Administrative Procedure Act, and I've got some ideas of ways in which we can amend that. But rulemaking is time-consuming, and also it involves the public and probably lawsuits. So what agencies have started doing is they've started issuing what are called guidance documents, and these are guidance documents or answers to frequently asked questions or flyers or things like that. But they're not called regulations, and they are not supposed to have the force and effect of law. But they do. And I'm going to give you an example. In 2019, the USDA posted a 2-page guidance document on the website for APHIS, and it said that by January 1, 2023, all of our cattle and bison producers would be required to use radio frequency identification ear tags.
Right.
Now, according to the USDA in 2013, which is, over a decade ago, the cost of that would be between $1.2 and $1.9 billion to the industry. $1 billion. And they just issue this mandate with a 2-page document posted on their website. That's a guidance document, and I sued over that and got it stopped. But those are the kinds of things that these agencies are doing it. You see it in the medical field a lot. Oh, yeah. Where they don't come in and tell the doctors, you can't do this, or you must do this, or this is the standard of care. They'll post a document that says, well, we believe that best practices are X, Y, and Z. And if you have a doctor that doesn't follow that because they don't agree with it, use COVID as an example. If you have a doctor that says, no, actually, ivermectin really does work, or hydroxychloroquine actually really works. I know this for a fact, but they put these documents on their website, and then if a doctor does not follow these guidance documents, they can be sued, they can have their license taken away, they can lose their ability to work in hospitals. It has huge impacts, and that's the way in which the FDA and these various agencies force doctors to do something, even if the doctors do not believe that that's the best approach to the medical issue in front of them. So
I don't think you and I've shared this with you in the conversations you and I've had, but my very first job in Washington, D.C., I was the reader for a blind environmental attorney. As it happened, he and his wife ran a property rights law firm called Defenders of Property Rights. So I was very familiar with the property rights issues and the public lands issues. He was representing a company, and this is during the Clinton administration, a chemical engineering company, and they'd gotten an interpretation from EPA about a particular statute in terms of how much material that they were using on their sites. And under this interpretation, they were below the threshold for the statute. New administration comes in. They change the interpretation of the rule, and all of a sudden, this company is being held criminally liable and not just, and it was essentially, it was a recirculating system. And so every time a molecule would recirculate through the system, that was yet another, it was counted. And so just these violations, and you know how expensive these violations can be.
Yes.
And so I just sort of sat there and listened as we're working on this and was like, there is something fundamentally wrong here. Oh, let's set aside, of course, the fact that there's no harm done. In fact, let me pull it back a little bit. I know we got a couple minutes left here. There used to be a principle in criminal law that you had to know that you were breaking the law. Specifically, you were breaking the law. You had to choose that you were breaking the law, and you had to have some kind of harm accrue from whatever law breaking you had chosen to do in order for something to be truly criminal, right? The whole mens rea or scienter requirement here. We've lost that. So when you have the combination of administrative courts and interpretation letters and people being held, criminally liable, it really does create a situation in which anybody's freedom can be under threat by a government with massively expansive powers, can it?
Yes, it's exactly right. I have a farmer that I represented in northern Wyoming. He moved an irrigation ditch. The EPA came in, brought an enforcement action against him, claiming that irrigation ditch was a navigable water of the United States.
Yeah.
When we went to trial on that case, which we eventually won, when we went to trial, he was facing penalties of almost $65 million.
Wow.
For affecting 2.1 acres of land on his own property because they had the authority at that time to impose penalties of $37,500 a day.
Wow.
So, and that was based upon a guidance document of the definition of what is a navigable water of the United States. That was not defined by Congress, and it was not defined in a rule or regulation. So that's the kind of crazy stuff that can happen. That's absolutely the case that they can do this.
My favorite recent story on that score. Now, you and I both know that the Clean Water Act says that regular farming activity is supposed to be exempt from the Clean Water Act.
Right.
But at one point, the Obama administration floated an interpretation that farm furrows were to be considered mini mountain ranges for the purposes of Clean Water Act regulation. I mean, this is where we are. So let's get into this because we got a couple minutes left. What are the next steps for the task force? What do you guys hope to be proposing down the road? What's going on with that?
So one of the things that we ultimately want to provide is better best practices, if you will, when you come to Congress. We need to become better practitioners, as I indicated. So when you talk about the Loper-Bright decision, that isn't really a substantive decision. It's a procedural decision as to who's going to interpret the law. And it used to be under the Chevron decision that they allowed the agencies to do the interpretation, which was totally unconstitutional. Now all the courts have done is they've clawed that back to themselves. But at the same time, if we do better at writing laws, we don't even need the courts to interpret them. They should be self-effectuating and they should be enforced as they're written.
Right. If Congress would just come out and say that private to private eminent domain is not legal under the Constitution, that public use means X, Y, and Z, then it's not up to the Supreme Court to decide that Suzette Kelo loses her house in 2005. So let me ask you this, Congresswoman, while we're talking about this. So Wyoming, well, first of all, how did you get involved in all of this? Were you always fascinated with this kind of law? How did you come here?
So I've been a water and natural resource attorney for many decades, and then I went to work for NCLA in 2019. I still continue to live in Wyoming, but just telecommuted. And obviously the Chevron decision was kind of our big white whale.
Of course.
And we wanted to take the Chevron decision out. But taking that out doesn't resolve the issues associated with administrative unlawful overreach. So NCLA then, and they continue to do now, is they continue to challenge regulatory actions that violate the Constitution. So I was, the RFID case against USDA, that was an NCLA case.
Right.
Regulatory agencies who refuse to allow mining, gravel operations, even though they're allowed by law. So just really looking at regulatory overreach, but also pretty much your entire constitutional space anymore in terms of real constitutional cases are in the administrative realm. And so as a constitutional attorney, someone who feels very strongly about protecting our constitutional rights, it was just natural for me to be able to be involved in those things. And then also with my background in agriculture, growing up on a ranch, being a water and natural resource attorney, a lot of the work I did was against administrative agencies.
So one of the things I like to do before I let my guests go, I almost was going to do a podcast at one point called Outside Interests, in which policymakers and policy people come in and they talk about the stuff they're doing that isn't policy related. Like I got a good buddy who does telecom policy, but he also plays blues harmonica. Another guy, Senate staffer, plays guitar. Somebody else does photography. So when you're not doing this work, you said you like to cook. What all do you like to do? What else when you're not doing this work?
I enjoy traveling. I enjoy spending time with my family. I have a huge family, primarily in Wyoming, with a few that have moved elsewhere. But my mother is 101 years old.
Wow.
And so when I get home, I spend time with her, whatever I can, and my extended family, my husband. I enjoy reading. I enjoy cooking, traveling. I enjoy the politics. I enjoy getting out in Wyoming, doing town halls, meeting with people, engaging with them on the issues that are important. Right now, Washington, D.C., there's a lot of interesting things going on.
Yeah.
And so I'm pretty immersed back here. And then when I'm at home in Wyoming, working with my constituents.
Well, when you're back home, and I usually ask this of members of Congress, not that you need to pick one favorite place over all the others, but is there some place, when you're thinking back and you want to get back home to Wyoming, some place that you miss, the place that makes you feel much better about the world when you go home? I mean, besides your house and with your family, but some place that you like to go.
The ranch where I grew up near Fort Laramie. But I also, I represent the entire state of Wyoming.
Yes.
So I'm a little unique in that regard. And fortunately, I get to get out and visit people all over the state. My state is absolutely beautiful. I encourage people to come and visit. Jackson is gorgeous, Yellowstone, but also we have just so many beautiful areas. Saratoga, northeastern Wyoming, northern Wyoming, Sheridan, Evanston, Alpine. It's just a gorgeous state.
I was fortunate growing up in that my parents were both largely academics. My dad could take a lot of time off in the summer, and we would drive across country because my mom's family was from California. And we would invariably drive through Wyoming, and it's just such a beautiful state. Congresswoman, how do folks find out more about the good work that you were doing? How do they find out more about this RSC task force?
So you can go to hageman.house.gov. And also we have a newsletter. They can sign up for my newsletter and just keep following what we're doing.
Our guest has been Harriet Hageman. She is the chair of this Republican Study Committee Task Force on Article 1. She is the at-large representative from the great state of Wyoming. This has been yet another episode of the Lunch Hour with Federal News Wire. As I state at the beginning of most shows, please come check us out. Subscribe if you haven't done so. Leave us a like, leave us a comment. If you're watching us on YouTube, you can take us with you on one of the many fine podcast platforms. If you're listening to us on one of those podcast platforms, you can check us out on YouTube. I am Andrew Langer. I want to thank our guest, Congresswoman Harriet Hageman. Enjoy the rest of your lunch.
This has been the Federal Newswire Lunch Hour Podcast, hosted by Andrew Langer. Check out the Federal Newswire's family of websites, as well as their social media stream